Seller's Property Disclosure Statement, SPDS. The seller is under no statutory or regulatory obligation to provide a property disclosure statement. Certainly, in the case of law, contract law, and the typical real estate sales contract, the seller has certain obligations, yet that obligation is often overlooked by the listing agent and the seller. Most brokers require that their agents obtain a signed SPDS from every seller, with exceptions. Those exceptions usually include: property has been an investment, never lived in the property. Family inherited the property from mom and dad, never lived in it, or have not lived there for decades. Seller is a principal member of the LLC that owns the property and therefore knows nothing about the property. Seller is an attorney acting on behalf of a client or estate in disposing of real property. Seller is being forced to sell the property by the courts. Listing agents are often faced with the dilemma of how to handle a client that, for whatever reason, prefers not to or refuses to complete an SPDS. Since the SPDS is a primary means of disclosing information, details, and defects, it is best for the listing agent to convince the seller of the importance of completing and providing the SPDS. We will now address some common issues relating to the SPDS in residential sales. As a buyer's agent, you have a fiduciary obligation to your buyer. Thus, you must promote and protect the buyer's interests. Since the seller is obligated by contract law and legal case precedents, as well as the default language in the contract, you should not write that language. Discuss the issue with the buyer, and at some point, while presenting the offer, alert the listing agent that such language would not be in the buyer's best interest. That will allow you to measure the listing agent's response. If the buyer is okay with waiving the SPDS, one option is to cross out Section 4A, the default language in the contract, and have the buyer initial that. However, doing so might inadvertently eliminate parts of the buyer's contingency. Thus, if the buyer is willing to do it, it would be best to write that waiver on page 8. The result might very well be that the buyer does not receive the SPDS, yet you should not willingly allow the seller to escape their obligation. If the counteroffer includes that language, then you have the opportunity and obligation to counsel the buyer and let them decide. The listing agent uploads the SPDS into the MLS, and it is simply signed and dated by the seller, yet everything was blank and incomplete. Is there any value to that document? No. An incomplete or blank document does nothing more than allow the seller and listing agent to believe that they have complied with the contractual obligation to deliver the document. The contractual obligation is to deliver, within 3 days, a completed AAR SPDS. A form that is simply signed and dated, with nothing complete, does not comply with the seller's contractual obligation to provide the SPDS. You listed a property owned by an investor that has owned the house for 6 years. All that time, the investor had 2 different tenants living in the property, and except for the time they bought the house 6 years ago, have not visited the property. You sold them this house 6 years ago, and in that transaction, your client conducted an inspection and received the SPDS from the owner. Now 6 years later, the house is vacant and you have it listed for sale. The seller claims, having never lived in the house, that they are unable or unwilling to complete the SPDS. During the listing process, up to this point, you have been inside the property far more times than the owner has. 6 years ago, via the SPDS and the inspection, the owner learned of several issues that exist on the property or have occurred in the past. Even though it was 6 years ago, and the seller never observed those issues, they are still obligated to disclose what they know. If you assisted the seller in the transaction, when they purchased the property, you both have the obligation to disclose what you learned during that process. The fact that you have visited the property more times than the seller, you have a heightened obligation to disclose what you know. A seller that has owned yet never lived in a rental still knows the answers to many questions on the SPDS, such as the address, the names of the legal owners, is it vacant or occupied, any foreclosure or trustee sale recorded, are the owners a foreign person per FIRPTA, Are there any rental or sale agreements in place? Any HOA claims against the property? Any past or present roof leaks? Any past or present termite issues? Is there a security system? Every one of those, and many more questions, could and should be answered by an investor owner that has never lived in the property, by the children that inherited a property, or the principal signatory of the LLC. Any listing agent that would take a listing and not insist that the seller complete the SPDS is a listing agent and broker that is willing to take on the liability of a failure to disclose or misrepresentation of a property. Another SPDS issue is when the listing agent does not insist that the seller provide a SPDS. They accept an offer, and that buyer cancels during the inspection period as a result of the inspection. And, as they are obligated to do so, the buyer provides you, the listing agent, with the inspection report when they submit the BINSAR to cancel. Note: per the AAR residential contract, line 222, the buyer is obligated to provide, at no cost to seller, copies of all reports obtained by buyer. Now the seller instructs you to put the property back on the market, yet still has not provided the SPDS. You have the email from the buyer's agent with the BINSAR and the inspection report, and you forwarded that email to the seller. Thus, both you and the seller are aware of potential material defects in the property. If you do not convince the seller to complete the SPDS now, or provide the inspection report to act as the SPDS, you could be considered to be in violation of Arizona statute, commissioner's rules, and the Realtor Code of Ethics, all of which require us to disclose all known material facts, updating the disclosure statement. If information you provided to the buyer changes after you've given him or her the disclosure form, you have a duty to disclose the new information. For example, if the roof starts leaking after you provide your disclosure statement, but before you actually close on the property, you must give the buyer information about the roof leak. Remember that this disclosure does not require you to repair the leak, only to let the buyer know about it. You may negotiate the repair issue as part of the contract negotiations. Reasonable minds might differ as to what property information is important and therefore required to be disclosed. When in doubt, it's best to disclose all property information to the buyer. 5 tips to help you, the buyer, get the most possible out of this one document during your due diligence period. Number 1. Read it thoroughly. The key to the SPDS is to read it. You don't want to move in and discover a leak in the roof that was disclosed to you in writing during your due diligence period, but you just didn't bother to read it. It happens. Take the time to read the SPDS cover to cover and make note of anything you are concerned about. Number 2. Ask questions. If there is anything you don't understand or that doesn't sit right with you, ask questions and do your research. One awesome tool to help you verify information is the Buyer Advisory. We did an entire video on the Buyer Advisory. If you aren't able to find the answers you need or aren't sure where to look, let your realtor know, and they may be able to point you in the right direction. They can also liaise with the seller's agent if you need more information from the seller directly. Number 3. Verify, verify, verify. The SPDS is completed by the seller, which means it's subject to human error and inaccuracies. If something is really important to you, verify it. What do I mean by this? Well, if you are only buying this home so that your kids can go to a certain school, be sure to call the school to verify that the home is in the catchment area for that school, regardless of what the SPDS says. The seller may never have had school-age children in the home and is just guessing. Another important piece may be verifying HOA dues. Do not leave anything up to chance. If it is important to you, do your research and verify it. 4. Sign it. You will be required to initial every page of the seller property disclosure statement, as well as signing and dating the last page. But what does your signature on this document mean, and should you be concerned? No, by signing you are simply acknowledging receipt of the document. Your signature does not mean that you accept the disclosure or that you are okay with the things they are disclosing. If there is anything disclosed in the SPDS that you disapprove of, you can include it in the BINSAR or if it is more than you can bear, you are not required to move forward with the contract. I will be talking more about the BINSAR process in future videos, so make sure you subscribe to our channel and hit the bell icon so that you are notified when those videos are released. Number 5. Share it with your inspector. If anything in the SPDS causes you concern, be sure to share it with your inspector prior to the inspection. Let them know what things you are worried about and have them inspect those elements more closely. For example, if the seller disclosed a leak at the front door during last year's monsoon season, you will want the inspector to pay close attention to how the leak was repaired, as well as how any damage was repaired. Additional real estate disclosures in Arizona. In addition to the property disclosures referenced above, Arizona real estate practices require additional disclosures in certain circumstances. For example, the standard Arizona real estate contract requires the seller to provide the buyer with a copy of a report showing a 5-year history, or the length of time the seller owned the property, if less than 5 years, of insurance claims filed on the property, called a Comprehensive Loss Underwriting Exchange Report, CLU. If a home was built prior to 1978, federal law requires the seller to disclose all information regarding lead-based paint and provide a pamphlet on identifying and controlling lead-based paint hazards. More information on lead-based paint can be found on the Environmental Protection Agency website. Depending on the circumstances, a seller might also be subject to the following statutory disclosure requirements. Swimming pool barrier disclosure. Arizier's Reverend Stat. Paragraph 36, 1681E. Condo disclosure information. Arizier's Revenue Stat. Paragraph 33, 1806 and 33, 1260. Notice of soil remediation. Arizier's Revenue Stat. Paragraph 33, 43401 and 49701 RO. Disclosure affidavit for land in unincorporated areas. Arizier's Revenue Stat. Paragraph 33, 422. Military airport disclosure. Arizier's Revenue Stat. Paragraph 8484.